and welcome to the second part of our FIDIC series. My name is James Murithi. I'm a civil engineer from Kenya. This is the second part of a three-part FIDIC series. And the whole purpose of this session was to bring young engineers to the awareness, please, to the awareness of what are the FIDIC contracts, the fundamentals. That is basically what we were able to cover in the last session. So just before I proceed, I would like someone to confirm that I'm clear. In the last session, we were able to talk about what are contracts, for that matter, some of the principles of contract, why we use standard contracts in construction. We were also able to go through some of the contract and the law that guides various contracts. After that, we were able to go through the standard forms of contracts, where we were able to go through some of them like FIDIC, NEC, and JCT. We also managed to cover the origin and evolution of. We were also able to review the famous FIDIC rainbow suit. And in this case, we were able to look at the yellow, red, silver, and many others in different scenarios that they can be applied. After that, we briefly managed to cover the various roles of parties in FIDIC contracts. And in case you missed the part one, that is the fundamentals of FIDIC contracts, my team is going to share that in the chat box right now. So Gatimu, please, you can be able to share the recording. It is live on YouTube, just in case you may need to look at it or probably have someone that may find it useful for that matter. So I want to welcome all of you to this session. And today's session is about the practical use of FIDIC contracts in construction. In the last session, I remember most of the questions that most of you young engineers were asking were basically centered around how do we then apply, manage different scenarios? How do we apply different clauses in the actual execution of the construction works? Most of you are asking how to manage various correspondences. Others were also asking about the specific roles of, for example, the engineer's representative, how do we handle disputes, how do we handle various contractual issues. So just in preparation for today's session, we are still having one and only super efficient engineer, Barasa Ugeti. He's the one who will be taking us through this second part. But just before that, I would like to hear what are some of your takeaways from the previous session, if you managed to join us? And probably, what do you expect to learn in today's session? And probably some of the things that you think or you expect the speaker to be able to address. So please, the session is open, and we thrive in order and discipline in this community. So number one, please make sure that when you're speaking to us, you are not in a noisy place. That is online meeting etiquette 101, because this recording who will be following the recording. So that's the rule number one. Rule number two, please be concise because we want to give most of the time to the speaker to share his knowledge and expertise. So please be very, very concise for that matter. And then the last one is we are mostly conversant in English. So that is a language that will be used in delivering this session. And we expect you to raise your question in that very same language. So I'm going to open it. You don't need permission to speak. So, but in case you hear someone has gone ahead of you, please just give them some time to speak. So I'm going to open the session for everyone who would want to share with us. I repeat again, this is the structure, your name, the country you are joining us from, what you do, what are your takeaways from the previous session, and what you expect to learn in today's session. The mic is open. Take it away. Thank you very much. The session is open for the participant to ask their questions, share your expectations, and some of the things that you would like to learn from us. Thank you very much.
Hello, everyone. Yeah, this is
Yes,
Jovin.
please.
Yes, this is Jovin from Uganda, and I'm a civil engineer. Yes, last time I didn't manage to join, but I'm happy this time round I'm on. Yeah, what I expect to learn from this session is that I expect to learn about the things which are required for one to sign such contracts. I mean, like the qualifications for one to sign such contracts. That's one of my expectations within this session. Yeah, thank you so much, Engineer James.
Thank you very much, Godfrey. That's from Uganda. One more person.
Hello, good evening. This is Kevin.
Yes, Kevin.
I'm in Kwale County, that's Kenya. So currently I'm in a project road construction. Though my role is assistant structural engineer. I'm working on preparing myself to go for EBK registration, and we have had a few issues. The contractor is really non-compliant. So I just want to see there's something I can learn from FIDIC condition of contracts on how to administer contract, and when you have a very stubborn contractor. Thank you.
Thank you, Kevin.
Hello.
Yes, please.
Yes, my name is Okiri Junior from Kenya.
Yes,
Well, I didn't
Okiri.
manage to attend the previous meeting, but I'm looking forward to learn on how the FIDIC is being applied, maybe in the preparation of the tender documents, more so the ones that are being sponsored by the World Bank. So the various clauses, the responsibilities of the contractor, the employer, the engineers, and maybe on how they resolve the disputes, maybe using the DABs, such procedures.
Thank you. Thank you very much, Okiri. That's well noted. Application of FIDIC contracts in World Bank and those funded projects. And thank you very much. One more person. We want to know what are your expectations so that we can be able to shape to ensure that the speaker is able to address some, if not all of them.
Maybe I may also add the engineer. I'll also like the speaker maybe to differentiate, because I'm always getting confused when it comes to the general conditions and the special conditions. So maybe you'll elaborate on that.
Thank you. This is Okiri Stiller.
Yeah.
Good evening.
Good evening.
My name is Daisy Gift Muganjizi from Uganda.
Yes, Daisy.
My expectations for tonight is how to effectively manage claims, disputes, and variations under FIDIC contracts to avoid project delays and cost overruns.
Thank you. Thank you. I think most of I may respond to that. We have the last session on contract, or rather on disputes and claims management. I think that will be best explained there. Yes, please. Someone was speaking.
Hello, engineer.
Yes, Kelvin.
My name is Fumbani Kondo. I'm from Malawi.
Yes.
My expectation during this session is much on. I work for a contractor, but I want to understand how a contractor can utilize the FIDIC in scenarios where there is a dispute which is coming from the client and the consultant, because there are some issues that come from the client and the consultant, not just from the contractor.
Yes. So the contractor is always sometimes on the receiving end, and you would want to know how to manage that, right? If I got you right. Thank
Good
you.
evening.
Thank you very much. Yes, good evening.
Yeah, this is Simon Mateli, an engineer from
Simon.
Kenya. I would like to understand how FIDIC and this era of PPPs get married, and to get to understand a better application of FIDIC in PPs. Thank you.
Thank you. I think that's super clear. That's noted. One more person before we shift the conversation.
Yes, James.
Yes, please.
Mine is, I didn't attend the first session. I wanted to, in Kenya.
Is this Kataboy?
Yes.
Okay.
Yeah, I want to, mine is based on timelines, yeah?
Mm-hmm.
It's from the PPRA, public procurement from Kenya side, yeah? Nowadays, I've been having a challenge on the timelines of various activities in the contracts, yeah? So probably between FIDIC, there's some variation between FIDIC and this one provided by the PPRA. I don't know how to go about that. Thank you.
I think I did not understand you, please.
I mean the timelines or in contract administrations, yeah?
Mm-hmm.
Timelines, for example, when I'm supposed to sign this one, because there was we had a bit of contradiction between provided by the Act and the Act, and those ones also by provided by the FIDIC. Thank you.
Okay, thank you very much. If I got you, is how to navigate the differences or just a conflict in timelines between the Public Procurement Act and the FIDIC contracts. Did I get it right?
Yes.
Super. Thank you very much. Now, I want us now to have someone who has had some experience handling one. I would like us to paint a picture, and this is how I would want us to go about it. Are you in this community and you are currently or previously and a very, very intense contractual issue, and probably did you get to solve it, or are there some of the challenges that you're facing? I know mostly people in Kenya, there are a lot of GOK government projects and all of that that are stalling. And I would like to hear one tangible or a case study of some of the challenges that you're facing currently with your project. Please, someone. And we want you to give us in detail such that we can build a case from that. If you're in this community, but of course you can be able to eliminate the specific details. You don't have to say the actual project, no mentioning of names and projects. Just build a case for us, paint the picture for us. If you're that person and you're comfortable, you can take the mic.
Hello.
Yes, Kelvin.
Yes. So as I had stated earlier,
Mm-hmm.
I'm in a project whereby I'm the assistant structural engineer. So I think in the matter of contract administration, I think that is a bit on a higher level for me, maybe in the office of RE and DRE. But there are some things maybe I may not be aware of. But in general, what we are facing at site is basically non-compliance with the contractor we have. It's a GOK project. And one of the major issues is actually taking care of the RE. I know for a project to flow smoothly, the RE need to be facilitated, and I think that's very basic for everyone who works in this project. You know, if the RE is not well facilitated, that becomes an issue. Say the inspectorate, myself, and the rest of the team. So it's a bit of a struggle for the RE. I may not have much because as I've stated, my role in the project, but I think the RE must be having a very difficult time with non-compliance, and that's just one issue. Other is on mobilization. So the project is on a very slow pace. Maybe some of the indicators that you check to see the progress of project, or whether things are going as they are supposed to, is maybe the mobilization. We talk of equipment, furnishing the RE's office and all, and all. So I hope this will help with the conversation. Thank you.
Very much, Kelvin, for sharing that. One more person, please. Share the experiences so that also people who have not earned probably these experiences, we can build the case as our speaker gets ready for us. One more person. One more person would like to share, build a case about a specific challenge.
Good evening.
Good evening.
It's Isaiah from South Africa. We're currently busy with the construction of the road this side. And sorry?
Proceed.
Yes, we were currently busy constructing the road this side, and the construction is not complete yet. So currently, the main contractor it's claiming for other damaged stuff that were paid already. But according to FIDIC, they were not supposed to claim those items because they already paid for it, and they did not do the handover for such stuff. So I think it's also something that has to do with FIDIC somewhere there. I'm not sure if it's under sub item 18 there or something, because we
Okay.
don't, yeah.
So if I got you right, you are in a situation where the works were executed on site,
Yes,
measurement was done, and a payment certificate was raised and it was
yes,
settled.
and it was paid.
And then the contractor is still claiming money for the works that were already paid.
For example, let's say something was damaged due to accidents or some other stuff. So now when they repair, they want to get paid for that, but they did not do the handover.
Is the project still under defects liability period?
Yes, it's not even complete, but the community can drive on some other lanes. So when accident happens, for in case if they hit the walls there or the guardrails or signs, they want to get paid for repairing that, which is not the case. They're supposed to fix them using the insurance.
Okay, fantastic. Thank you very much. I would like someone to give us insight, someone who has had some experience on that. How would you approach such a contractual issue? Someone, please.
I'm sorry, if the presenter doesn't mind, can you please repeat the scenario, please?
So the scenario is the contractor, the contract is still ongoing. And in this construction project, the works for a certain section has already been done. Please stay muted if you're not speaking. So I'll repeat. This is the scenario. It's a road construction project. The contractor has already executed works, let's say for kilometer 1 to kilometer 2. The RE and the contractor has already done measurement for the works. The certificate has been raised and already it has been paid. The contract is not yet complete. It's still under the defects liability period. Within this time, there is an accident that occurred in the completed section and some damages were done. The contractor went back to repair the damaged section. After repairing this, he is raising a claim to get paid for those repair works. Is this right or wrong? How would you handle such a scenario?
100% correct.
Well,
how would you handle that?
Well, the scenario, in the way I understand it, that the contractor has completed one part, a section of a road, and has not handed over such works.
You're right.
Yes, they did not do the handover. They will do the handover once
And
everything.
in the process, it gets to be damaged.
Yes.
I'm sorry. I just want to understand the case. It's like I'm creating the facts of the case.
Yes, proceed. You're right. You're on the right trajectory.
Yes, that the contractor, I mean, the contractor has completed one part of the section. He has not yet handed it over the project, and there was an accident that he had to attend to, and then he's claiming for the damage. My understanding is that in the framework of the FIDIC, the role of a contractor and the job is to maintain, I mean, to construct the permanent works as required, as per drawings, as per standards. That's the number one job. The second one is site security, to secure the works, to secure everyone at work and everything. That's why he has to counter for the risky amenities as provided for in the contract. So until when all such issues have happened under his responsibility. So in my opinion, as per FIDIC, he's not entitled to the claim that he's actually citing for. So if I were the consultant, I would simply advise it is his responsibility to maintain them until when he hands them over. Once he hands the works over to the client, that's when we can discuss. And even at that point, we'll have to discuss, are they defects or damages? That is the different case in my opinion. That's how I would approach the case.
Thank you very much. That's a solid response. I would like one last person. We have 2 minutes before now we have the guest speaker take over the stage. Someone else would want to comment on the same or having a contractual issue, you can share with us. Yes, Stanford.
I agree with the previous speaker.
when he said defectless period, and also mentioned about the risk amenities. Sorry, just to introduce myself, I'm Stanford from Zimbabwe, civil engineer. So in Zimbabwe, we have car, that's a contractor or risk insurance. So that's the one that you use when you are doing the contracts. But now, going back to the scenario, which the road construction, it also depends with the type of contracts. Some are getting into contracts with different agreements. Some on an MOU. Some they just do a BOQ, priced BOQ, and just agree that proceed with the works. So now it depends with the type of contract that they have with that's the consultant and the contractor. Obviously, the consultant is on behalf of the client side, and also there's a relationship between the contractor, the client, and the consultant. So now, I can just say it depends with the type of the contract they have. So, but if the type of the contract they have, okay, just to clarify, FIDIC, right? Some they don't understand FIDIC. They just get into contracts. So now we need to know the type of contract they have with the contractor. Then we'll be able to determine is it okay or not.
Thank you. Thank you very much. That's a great perspective. And I want also to thank everyone that has been able to share with us some of their challenges that they are having in administering contracts in their various projects, and also some of us that are able to share with us their expectations. Ladies and gentlemen, it is my time now to do my honorable job, which is to introduce the speaker for the day. And the speaker for the day goes by the name Engineer Barasa Ongeti. Barasa with S, not Z, not Baraza, but Barasa. He is a FIDIC certified contracts manager from Kenya. He is also a registered professional engineer with the Engineers Board of Kenya. He is also the co-author of FIDIC Contracts in Africa and Middle East, a book that was published in 2024. Engineer Barasa Ongeti has a strong academic foundation in civil and structural engineering, management. He currently serves as a contract manager at overseeing major projects across Africa, including Angola, Mozambique, Ethiopia, DRC, Tanzania, Ivory Coast, and Uganda. With over 9 years of experience, Barasa brings in-depth expertise in FIDIC contracts, contract administration, dispute resolution, and income protection strategies. His background includes a significant tenure at consultancy where he handled complex claims and contractual issues in infrastructure projects across East and West Africa, as well as Southeast Asia. He has worked across various sectors, including data centers, roads, ports, and water infrastructure on both public, private projects with international contractors. Ladies and gentlemen, let me welcome Engineer Barasa Ongeti. And just before he takes over, I would like to present some of your presentations, or rather some of the expectations that you have in this second part of our 3-series event titled Practical Use of FIDIC Contracts in construction. Engineer Barasa, some of the expectations of your audience includes, number one, we and Kevin from of a project that he is handling where there is a lot of non-compliance from the contractor side. To be specific, he's saying that the RE is not facilitated and the contractor is stubborn, just to use these ones. We end another issue from Okiri, where he was talking about he is not very clear on how to uh, 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 interpret probably or apply the difference between general conditions of contract and special conditions of contract. Fumbani from Zimbabwe also talked about he is working for the contractor, and he says that he is on the receiving end from both the RE and the that is the consultant and the RE. So he's looking into some of the strategies on how to handle this from the perspective of a contractor. Katamboi from Turkana County says that he is having an issue with timelines conflict between the Public Procurement Act that is in Kenya versus the FIDIC contract specifications. So ladies and gentlemen, let us welcome Engineer Barasa to take us through practical use of FIDIC contracts in construction. Engineer, please take it away. Thank you very much. You're much welcome.
Thank you, James, for the glowing introduction. It's a bit late in the day, of course, and like most of you, I'm sure we've all had a long day, so I'll not keep you here for long. And that also means that, unfortunately, I'll not have sufficient time to answer in detail some of the questions that you've raised, because you understand some of these topics are full-day topics. They cannot be answered in a one-hour session or seminar. So you'll pardon me for that, but I hope in the course of my presentation, I'll cover some of the aspects, even if touching lightly, on what you have said. I hope my voice is clear enough. It's been a long day of speaking a lot, so I may be rough on the voice, but let's see where we go.
You are clear, engineer.
Okay, great. So today's topic is practical use of FIDIC contracts. That's a picture of myself. I look a bit different from that. The hair has grown thinner since I last took that picture, but it happens to be the only professional looking photo that I have. So when Rhodes have requested me for a photo, that's the only one I could get. But I'm the guy in that photo. You just have to believe it. What will we talk about today? Today, we're going to talk about, as I said, we'll not cover all the issues that you've raised, but I hope that in the course of our discussion, we are going to cover some of those. And today is basically a continuation of our first part of the webinar, which we held about 2 weeks ago. And we're going to have a third part where we'll cover some of the issues. The issue raised by Daisy Gift about effectively managing contracts and contract claims and disputes will be in the third seminar. The issue raised by Fumbani as well, how the contractor can utilize the contract during disputes, that will be in the third seminar. So at least I'm guaranteed that the third seminar will have 2 attendants, Daisy Gift and Fumbani. And perhaps others, the Kelvin Macharia who says they have a stubborn contractor. Being stubborn is essentially what you mean when you say there is a dispute. So we'll cover that in the third seminar. But for now, I'll just do a refresher of the present. Give me 1 second, please. I don't know if my camera is proper, but so during the third seminar, we'll cover all that. For this present seminar, what we're going to do is start with a refresher from the previous seminar. I'll just highlight some of the things for the benefit of those who are not there in the last seminar. Then we'll look at the red and yellow book 1999 and compare it to 2017. This may sound new to those who are not here in the second seminar, but for those who are here, sorry, the first seminar, for those who are here, you'll be familiar with what I mean when I say red and yellow book, and when I say 1999 and 1997. We'll only have time to look at employers' responsibilities, contractors' responsibilities, and engineers' responsibilities. I've heard that some of you work for the contractor, some of you work for the government bodies, and others work for the engineers or aspire to work for the engineers. So at least some of your roles will be touched, and what you're expected to do during the contract execution will be touched upon during this seminar. Then we'll only have time to look at key contract clauses. As I said again, most of these topics are full day topics. We cannot cover them in a 1 hour seminar, but at least we will have time to look at measurement and valuation, payment, and extension of time. Then next time we will look at disputes. Those are only about 4 or 5 clauses, and FIDIC is made up of 20 clauses. So you can understand that we're not even scratching the surface, but it's because we are limited of time. And of course, perhaps in future sessions, who knows, we may have time to look at them in depth. But ordinarily, going through the entire FIDIC course takes about 3 to 5 full days. And I mean full days from 8 a.m. to 5 p.m. to cover everything. So bear with me on that. If we find time towards the end of this seminar, I may address the questions you raised one by one. Okie dokie. So let's start with a refresher. What did we speak about last time? Last time, we said that a contract is a legally binding agreement between two parties and it's enforceable by law. The key operational terms there is 1, it's legally binding, and 2, it's enforceable by law. So when something goes wrong, you have the recourse of law to go to. You can run to the law. Last time, we also said that a standard form of contract is a pre-prepared agreement which with standardized terms and conditions that parties can use repeatedly for similar transactions. So you have your standard form of contract, okay? You can go with it from Stanford's country to Esaias' country. You can go with it to Daisy's country, and it's a standard form that is utilized. Kataboy raised PPRA, for example. PPRA is the Public Procurements Regulatory Act of Kenya, and they publish a contract, I believe it's called the PPRA contract, some public procurement contract. But if I go with that to Stanford's country, it may not be recognized there because it's new to them. But if I use a standard form of contract, it's globally recognized by different contracting entities, and they'll know how to operate within the terms without much negotiation or discussion about its contents. So that was the purpose of standard forms of contracts, and we looked at different standard forms of contract. We saw there's JCT, we saw there's NEC, we saw there's FIDIC, and many other forms of standard forms of contract. We also asked ourselves, what is this FIDIC that we keep hearing about? And we agreed that FIDIC is an acronym meaning the Federation of International Consulting Engineers, but in French, of course, translated into English. And this is the umbrella body of consulting engineer member associations globally. So each country has a member association, or at least an associate of FIDIC, and this is what is called a member association. It's a national association, which is an association of firms which provide technology-based or intellectual consulting services for the built and natural environment in a country. So whether in Lesotho, whether in Swaziland or South Africa or Switzerland or United States of America, you have an association for all consulting engineers in that country. Okay, and these consulting engineers have formed an umbrella body called FIDIC, and they're all members of that umbrella body of all consulting engineers. So over 60 countries globally are member associations of FIDIC, okay? And those are just some of the members. We have ASEC from Kenya, you may recognize that logo. NAEC, I don't know which country that's from. Maybe if you recognize that one, you can type it in the chat. Indo, that's from Indonesia, I believe, consulting engineers of Indonesia. We have Consult Australia National Office. We have CESA from South Africa. We have the Uganda Association of Consulting Engineers, and Ghana and Nigeria and what have you. And all these countries are all members of the global umbrella body of consulting engineers called FIDIC, the Federation of International Consulting Engineers. And this federation has come up and said, look, engineers, we need our contract, a contract that is recognized globally. Wherever we go, this contract will be recognized and will say it's published by us, FIDIC. And that is where FIDIC came up with the standard contracts. So FIDIC was founded in 1913. We spoke about this. We said that it published its first standard form of contract in 1957 and more editions in 1987. We say that it followed by a rainbow suit in 1999. And then in 2017, they published the second edition versions of the red, silver, and yellow books. We said also that these terms red, silver, and yellow come from the color of the cover of the book. For example, on your screen, you can see that there's the red book, there's the yellow book, and there's the silver book. So simply put, these colors are used as identifiers of these different books. And these different books are used under different circumstances. The red book is not applicable for all contracts. I believe it was, who was it who asked this question? I think it was Simon who asked how can FIDIC be applied in PPPs? Unfortunately, we answered that in the first seminar. In the next slide, I may answer that in less depth than I did in the first seminar. But how can FIDIC be applied? You apply FIDIC by choosing the correct color of FIDIC. From all the suits that you have, you choose the right one for PPPs. How do you make this choice? You answer the following questions. How complex is the project? Is it a fairly straightforward project that takes 3 months to complete? Is it a road project that you as the Roads Board of Uganda have done over and over? Or is it a more complex port project, a hydropower project, a nuclear plant project, perhaps, which is more complex and, of course, requires a stringent contract? Who carries out the design? Is it the contractor or the employer or his agents? Is there certainty about contract price and contract time? And what level of engagement does the employer require in the day-to-day execution? So we spoke about all these things last time, and I'm just recapping them. Is there some level of maintenance required? And does the employer want a turnkey project? So when you answer these questions, each of these questions direct you to which form of contract you're going to use. Now, just to see from the people who are here last time, I know there are several, I think more than half of you are here last time. I want to see by giving you a challenge. Which form are you going to use in this case? There's a question mark on the right of the screen. Once you give me the answers, the question mark will reveal whether you are correct or wrong before we proceed to the meat of today's seminar. Which FIDIC book are you going to use? So let's say case one. Aliko Dangote wants a contractor to handle both the design and construction of a new food processing factory in Swaziland. The contractor is expected to take the responsibility for the design. Let me see who was paying attention last time. What do you think will happen there? Which FIDIC book will be used? Anyone? Just shout and let's hear you say. I see there's a chat. Almost revealed the answers. Aha. Ahmad says silver book. Alphonse says red book. Ah, Munoru says yellow book. Okay, so Aliko will use all three. Oh, yellow book. Okay, quickly, silver book. Okay, quickly. Let's see. Ahmad, if your microphone is on, just say why you say silver book.
Hello, sorry. I think I meant to say silver book, yellow book, not silver book. And why I'm choosing silver book is because the contractor is doing the design. In this case, it is yellow book, not silver book. I made a mistake to say silver book.
Okay, Gatimu says both red and yellow. Gatimu, why do you say so? Gatimu, if she's not ready, Given says yellow. Given, why do you say yellow? Okay, he's not ready. Let me see who else I can choose to say. Who said red? Somebody here said red. Who was it? Alphonse.
It's given here.
Yeah, given. Yeah.
Yes, I say yellow book because the yellow book you use it for design and build.
Perfect. Thank you. Alphonse, you said red. Why did you say red? Okay, Alphonse is not ready. We'll come back to him later. Let me move to the second one. That one is closed, poll closed, so no more responses for that one. We'll find out. The second one is the Ministry of Works and Transport in Uganda wants to build a toll road from Jinja to Kampala using their own design consultants. The contractor will carry out the construction work based on the employer's design. Which book is this? Red, that's Mr. Otto. Paidamo says red. Overwhelmingly, everybody is saying red. So I think we are all agreed on red. Daisy says red. Gatimu says red. Kelvin says red. Everybody says red. Let me choose the last person. Sebastian, why did you say red? Okay, I see Bitamazire and Munoru and Hillary. You're already on silver. Okay. Renee says yellow, red, silver. Okay. Fine. I'll reveal the answers so that we move to the next slide and I'll justify them. The first one says it's a design and construction, and the contractor is expected to take responsibility for the design. So everybody who said yellow, you are correct on that one because the contractor takes responsibility for the design. I didn't understand. Perhaps there was a reason somebody said red and yellow, but she didn't speak up to say why. But I didn't understand why you want to mix the two. You choose one or the other depending on the most suitable. Okay. The second one is the design is being carried out by the employer's design consultant. And obviously that one, you're going to use the red book, the conditions of contract for construction. And actually, if you read the full title of the red book, it's called Conditions of Contract for Construction of Works Designed by the Employer. Okay. The third one, for everybody who has said silver, you're absolutely correct. It's a turnkey solar power project, and the silver book is specifically for turnkey projects. Okay. And the contractor does the design, construction, testing, and delivery of the plant. And of course, the employer puts his feet on the desk and has little involvement, neither in design, neither in construction, only during payment. The silver book prefers a lump sum project or pricing, of course, pricing system with maximum risk pushed to the contractor. So it's mostly used for such kind of projects. Okay, so if you said silver, you are absolutely correct on the third one. Perfect. We're still doing a refresher until we move to the meat of today's seminar. And usually to demonstrate the risk, because here we said maximum risk on the contractor. I draw this graph here to demonstrate the risk apportionment of these different books to the different parties in the contract. So on the left, I have that arrow where it starts with an increase in risk for the employer and it shifts to an increase in risk for the contractor. On the lower side, decreased risk, or rather, not decrease, but increased risk for the employer, and on the upper side, increased risk for the contractor. And then we have a medium line there, of course, that's where there's a balance. And then on the right-hand side, I have another scale. At the bottom, you have increased design control by the employer. So the employer wants their fingers in the design a lot more. On the other hand, at the extreme end of that scale, you have increased cost of project, which means that's the balance you want to strike. So depending on which of these factors you as a contracting agency, some of you here work for your governments or for contracting agencies or for developers who will be engaging contractors in your projects. And to do so, you'll need to know which book to use, and to guide that discussion or to guide that solution. Other than the questions I presented, you have this scale here, which will tell you that if you use the red book, then you're increasing the risk for the employer. Why is the risk increasing for the employer? The risk is increasing for the employer because this is a remeasured contract, okay? It's not a fixed price or a lump sum price contract. And a majority of the works will be remeasured, okay? By remeasured, I mean the works will, at the end of the project, the bill of quantities will be adjusted to reflect the actual quantity of works executed. And of course, that means at the beginning, the employer does not know the exact contract amount that they're going to spend. So that's the risk on the employer, okay? As we move further up the scale, somewhere in the middle, you're going to have the yellow book, which is sort of a balance because there's an increase in risk for the contractor, and the contractor will not necessarily bear all the price risks, but the contractor will most likely bear the design control. So the contractor will, there's a balance between the design control by the employer and the design control by the contractor and the risk by the contractor. And finally, the silver book. When you push all the risks to the contractor, obviously the contractor will have to price for all those risks. If it's unforeseeable ground conditions, if it's failure to complete on time, if it's a hydropower project with a specific output that is required. For example, you're building a 95 megawatt power project and you say that you want nothing less than 93 megawatts. The contractor will have to price for that risk in one way or another, and that is going to cause an increase in the cost of the project, okay? So that will cause an increase in the cost of the project. Great. So I think we have done enough of a refresher. And now we're going to get into, oops, how did that get there? We're going to get into the meat of today's seminar, which is am I sharing my notes or am I sharing my slides? Wait a minute. Okay, I think I was sharing my slides. Give me a second, please. 1 second. Matthew Ochoria, your hand is up, please.
Yes, please. Sorry for interfering.
No problem.
Thank you for the refresher.
Mm-hmm.
I work for the government on contract, man inspector.
Okay.
I do less of contract management, but during implementation, I face those challenges as I report to my contract manager. One, you talked of the red book, whereby most of the times they are ad-measured contracts, and the contractor is paid based on the value of work. And when you get to the Ugandan system, based on the little glance that I've had on our contract, the contractor is issued a contract, yes. And in that contract, we see there's a planned contractual figure, let's say 7 billion. Upon implementation, remember here that as the client, the employer, we have given the contractor the designs. But now a contractor, there are scenarios, you find a smart contractor who will tell you, I'm also going to I'm going to check your CSV data, for example. He picks up that data. Most of the times we do it jointly, where necessarily we calibrate it so that it doesn't seem like it's a new data set that he has gotten. However, upon payments, you realize because of unavoidable site conditions, technically, if a contractor is a person who is after meeting the quality standards, who will definitely do the work or maybe raise the road where necessary, have the right quality control procedures followed. Now, on time for payments, I've faced a challenge in two projects. A contractor will do the work, but the government, as the employer, will now say, I will not pay you for any work exceeding what has been planned. Remember, there are two statements I'm looking at. At the measured contract, I pay you for the value of the work done, but upon you requesting for that because of avoidable circumstance, I, the client, I tend to resist to do that. Now, in our system, we have the Solicitor General Office. It passed, at some point, it passed a law and it said no more payments for variations. Now, in such a scenario, how do you protect a contractor? He has done the work to make sure that quality is not compromised for the common man and for the common good, but at the same time, he's making a claim because the figure is exceeding, let's say 1 or 15% of the original contract. How does FIDIC come in? What should such a contractor, because most of the people who are doing these contracts under ministry, my department for community roads, they don't easily read this. They don't pay attention on these FIDIC rules. They don't pay attention more into the contract. They look at more on the figures. But at some point, you feel sorry for the contractor. You as a person, as the engineer, even if you're the client, or for my sake, for getting this knowledge clear, how can a contractor be helped? How does FIDIC come in?
Thank you.
To help
Thank
the
you,
contractor?
Matthew.
Yeah.
Thank you, Matthew. Just a small pointer to anybody who will come up with a question next time. Please just keep it concise. But thank you, Matthew, for your question. So what you're asking is there's a conflict between the regulation passed by the Solicitor General and the provisions of the conditions of contract. That's a very common dispute, happens all over the world. There's an existing law, and I think it's also what Kataboy Jacob said. There's an existing law, and it conflicts with what is in the contract. So which one comes superior? Now, if you signed a contract and the contract provides those provisions, remember last time from the definition of a contract, what is a contract? It's an agreement between two or more parties enforceable by law. And we spoke of governing law and applicable law. So the applicable law in this case is the regulation by the Solicitor General on variations of price. If there's a dispute, and there's a dispute on how these works are going to be measured, any court of law or any arbitrator or any dispute adjudication board will resolve that dispute by looking at the applicable law. So if the law clearly says no variations are going to be paid, too bad, Mr. Contractor. That is the law, and you signed a contract which states that you're subject to the applicable law. I hope that's clear and very concise, but that happens a lot. There's laws which conflict with the contract, and it's important that each time you want to do works which are outside of the contract, you have to, you have to look at what the contract says, and upon exhausting the mechanisms in the contract, what the governing and applicable law says about that issue. I hope I sufficiently answered your question, but I mean, it's a common situation. Let's proceed. We have quite some ground to cover. If you have any questions, I'd recommend, I'll give you breaks at some point. So just note down your question and we'll have a break in a few minutes so that we can answer our questions. We are short of time. I think we have only about half an hour left and there's quite some ground to cover. Okay, so what is a contract life cycle? The FIDIC form. The FIDIC form has a contract life cycle which starts from beginning to end, and it's well defined within the pages and the clauses of FIDIC. It starts usually at the issue of tender documents. What happens? The employer or the contracting authority prepares a set of tender documents. So you have your specifications, you have your employer requirements, you have your tender drawings, and perhaps if available, a conceptual design, which you call a tender document, and you have your budget. And you issue this to bidders or tenderers. And you request them to price the works for you and give technical proposals. So the contractors will give a technical and a financial proposal. In some places, you'll hear cost proposal or economic proposal or different terms for that, but that is what is called a tender, okay? And there's then going to be submission of the tender. Now, once the contractors or the bidders have reviewed the tender documents, they've raised any questions or clarifications, they've done a site visit and so on and so forth, and they've ascertained the ground conditions. Again, this comes to your question, Matthew. They've ascertained the ground conditions that this is the situation we're going to construct in, and they have satisfied themselves. Again, Matthew, I'll refer you to a certain clause as we go ahead of the contract, where the contractor shall submit their tender upon having satisfied themselves as to the existing data issued at tender, site data. So the employer has made available for the contractor's information prior to a certain date all relevant data on subsurface conditions, hydrological conditions, and so on, including environmental aspects. And the contractor acknowledges that they're satisfied with this, and they submit their tender. So that's the next step. But before that, there's a period. So that's called the tender period, of course, between issue of tender documents and submission of tender. And contracting authorities like governments and so forth will prescribe what happens within that tender period. Questions and clarifications, objections to the tender if there's anybody objecting, and so on and so forth. If it's a private project, it's less stringent than it is if it's a public project. But before that, we have something called the base date. What is the base date? 28 days prior to the latest date for submission of tender, we have a date and we call it the base date. It's very significant in terms of the contract. Many parts of the contract you'll see prior to the base date, the contractor shall ABCD. Prior to the base date, the employer shall ABCD. There are many obligations which are tied to the base date, which is ordinarily 28 days before the submission of tender. After the tender is received, you have a period, of course, where the owner will negotiate and consult with the selected tenderer and finally settle on one. If there are 3 or 5 or 20, settle on one, and then they'll issue them with a letter of acceptance. Within 28 days of the letter of acceptance being issued, the contractor is meant to provide something called a performance security. And this is governed by clause 4.2 of the FIDIC conditions if you're looking at the 1999 books. The performance security is a document which guarantees that the contractor shall carry out proper performance of the works, and this is a percentage of the contract amount. And the performance security, being a percentage of the contract amount, simply says that if there's a default on the part of the contractor, the employer can be able to do what is called encashment or recalling of the performance security, which will then remedy or give relief to the employer. So if, for example, the contract specifies that there's certain obligations under the contract which must be performed, one of them is completion. The contractor must complete the works. If the contractor abandons the site, the employer can go to the bank or the financing institution and say, hey, you gave me this performance security in place of the contractor finishing my contract. Mr. Contractor ran away, so I want my money back. Give me my money. So within 28 days of the letter of acceptance, the contractor must issue the performance security. After the performance security is issued, only then shall the commencement, and this is governed by subclause 8.1, only then shall the commencement begin. The commencement is ordinarily issued by what is called a notice to commence. In other countries or other quarters, you may call it a notice to proceed, I believe, or start order. There are many different terms, but FIDIC calls it a notice to commence. Under subclause 8.1, the engineer informs the contractor, I've received your performance security, you've received an issue of acceptance a letter of acceptance from the employer, and we have accepted your tender and everything is in place. You may commence the works. So please note that when you issue a letter of acceptance, ordinarily you sign the contract at this stage. Ordinarily, the contract is signed at this stage. That's not the date of commencement. So if your contract is for 2 years, you don't count it from here. You count the 2 years starting from there. Understood? Understood. So the letter of commencement states the date of commencement. Once the project starts, now the contractor will have a period to execute the works, and that is called the time for completion, and it's governed by subclause 8.2. Now, on this scale, I've made the assumption that the contractor will delay in completion. Okay, that happens a lot. The stubborn contractor faced by Mr. Kelvin Masharia is likely to delay completion. And at some point, they're going to have to finish the work. So once they finish, they're going to do tests on completion. That's governed by clause 9.1, tests on completion. And once the tests on completion are complete, then that is the end of the project. But is it really the end of the project? No, because the engineer yourself will have to issue a taking over certificate, and you state that Mr. Contractor has satisfactorily completed the works and the tests on completion have passed. So if it's a road project, what tests on completion ordinarily would you do? Material tests on the final surface, lighting tests on the road furniture perhaps. If it's street lights, are the street lights operational? If it's a toll road, are the toll gates operational? Those are the tests which are prescribed in the specification that must be passed. And once those tests are passed, the contractor submits what is called as-built documents, and you issue the taking over certificate. But the contract does not end there, it proceeds. You have a period for notifying defects, and it's governed by clause 11. This period is called the defects notification period. And if any defect arises, this was the question raised by, who was it? This was a question raised by Isaiah. Isaiah said that the defects are occurring here. They're not occurring here, which is a very distinct issue, but we'll sufficiently answer it in due course. So if defects occur, the employer or the engineer will notify the contractor, hey, Mr. Contractor, there's a defect here, there's a pothole here, there's a light bulb which is not fully functional, there's a toll gate which is not operational, and that's a defect, it's not conforming with the contract, please proceed and remedy it. So you have a period for remedying of defects. Once all the defects are remedied and to the satisfaction of the engineer or the employer, you issue what is called a performance certificate, okay? Once you issue the performance certificate, now the contractor is relieved of performance of their obligations under the contract. After that, within 21 days, you return the performance security, which you took earlier on. You return it to the contractor and you say, Mr. Contractor, thank you very much. I'm happy with the work that you've done and you've satisfied all the obligations under the contract. I've paid you and I've satisfied all my obligations under the contract. Thank you very much. See you next time. So there's that contract life cycle, and it's governed by different clauses. I've highlighted the key ones here: 8.1 commencement, time for completion, test on completion, performance security, and so on. So you can imagine between 4.2 and 8.1, there's 5, 6, 7, and 8. And of course, before 4.2, there's 1, 2, 3, and 4, and so on and so forth, all the way up to 20. And that is how you should look at your FIDIC contract whenever you're looking at it for ease of understanding. It's very linear. It starts with the first clause and ends with clause number 20, and they're all sequential following this contract life cycle. It makes it easier for you to understand a contract, depending on at which point of the contract you are, okay? We covered this last time, so I've put a circle around the first two, which will be the focus of our seminar today. We're not going to look mostly at all the rest, but if you grasp the understanding of these two, you may be able to apply the principles to the other. Again, this is due to shortage of time and the limited time that we have. But of course, I'd be interested to share more with you in future sessions. As I've just mentioned, and we covered this last time as well, we're only going to look at FIDIC 1999 and concentrate mostly on red and yellow because we don't have time. So the red and yellow book of FIDIC 1999 has clause 1 to 20. And this is by grouping. This is not in the contract. The text in green is only by grouping. I group it that way so that I also understand the contract. We have general items and definitions. Those are given in clause 1. We have parties to the contract. The ones in blue are the parties to the contract. Mark you, the engineer is not part of the contract. He is not. The parties to the contract are the two people who signed the contract and state they're legally bound by the contract. And that is usually the employer and the contractor. So the engineer is not a party to the contract, but he acts on behalf or for the parties of the contract. That's why he is classified there. Then you have clause 6 and 7, staff and labor, plant, material, and workmanship. So this talks about what how the contractor will do the recruitment of staff, labor. We talk about health and safety, plant materials and workmanship, samples, and all those things which the contractor is obligated to do. Then you have clause 8 to 12, which talk about time for completion and execution. So commencement, delays and suspension, tests on completion, what happens on taking over, the defects, if any are there, tests after completion. This is only for the yellow book. There's no tests after completion usually for red book. Right? And then you have, for example, why? Well, let me say why I think FIDIC said there's tests after completion for yellow book. You're working on, let's say, since most of you are roads people, you're working on a roads project under a yellow book where the contractor did the design. But you want to do tests after you've completed. What kind of tests would you do ordinarily for a yellow book? Something that you've designed, you want to carry that liability even after completion, right? That it functions properly. So you want to see that the traffic design or the traffic capacity that you did for that toll road, for example, is sufficient. And so you do some tests. So the specification will prescribe some tests which you ought to do after you complete, traffic counts perhaps, or toll road timings, how much time is spent on a toll gate, for example, and so on and so forth. I mean, the myriads of tests which may be prescribed after completion. I think that's why FIDIC put it there. Then we have clause 12, 13, and 14, financial control. Then we have clause 15, 16, 17, 18, and 19, which is risks and liabilities. And that would answer the question again, the question by Isaiah. It's all in there, risk and responsibility. Clause 17, if you go and look at it, your question is clearly answered in there. And if you have a stubborn contractor, then clause 20 will address it, which is called claims, disputes, and arbitration. So everything is actually covered in the FIDIC contracts. Unfortunately, due to time, we do not have enough time to cover all those. So I've only selected a few. I'm going to cover clause 2, 3, and 4, and I'm going to cover clause 8, and I'm going to cover 12, 13, and 14 very briefly and just on the surface. In future sessions, we may have a look at all the rest. Okie dokie. So I'm going to show you a sample clause in FIDIC. How it looks like for the benefit of those who've never opened a FIDIC contract. This is copyrighted material, but generally that is how it looks like. What you have there on the screen is how that is called clause number and name. So this is clause number 1, general conditions. Then you have what is called subclause. So this is subclause 1.1 definitions. So clause number 1 will have several subclauses. Subclause 1.1, subclause 2, 1.2, clause number 2 will have several subclauses as well. 2.1, 2.2, and so on and so forth. Okay. Here is another clause. You may immediately guess that this is clause number 11, and it's called defects after taking over. So that, again, is the name and number of a clause. And that, again, is the name and number of a subclause. So this is subclause 11.1, completion of outstanding work and remedying of defects. So you can see that it goes on to say blah, 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 and then it has subparagraph A and subparagraph B. Okay, so that is a subparagraph, which obviously makes anything above it a paragraph. So whenever you're handling any of your contracts and you're managing them, this is how you reference the FIDIC contract: a clause and a number and name, a subclause which has a name as well, and a subparagraph. So Mr. Junior, if you are instructing your contractor about something, you're referring to a clause, you'll say, in accordance with subclause 11.1, subparagraph B, they'll know immediately that's what you're referring to. And that's the standard conventional method of referencing the contract. Okay. I've seen some questions, I've noted them. I've seen some questions in the chat. I'll address them. They're very relevant and interesting. I'll address them. Now, the contract has something called defined terms. If you look at the clause I'm projecting on the screen, it has some capital letters. The capital letters are what we call defined terms. The defined terms, for example, we have works, we have contractor's document, you can see capital C, capital D. We have section, capital S. The defined terms are usually drawn from here. So if you open your FIDIC contract under definitions, anything which is in here, you'll find it in the contract with a capital. Why is it put in capital? It simply means that it's a defined term. It has a specific meaning. So you cannot say claim, and this I find a lot with engineers, yourselves, when you're practicing. You say that the contractor has submitted a claim for payment, when you actually mean he has submitted an application for interim payment, an IPC, but you're calling it a claim. But here it's a claim or an entitlement for relief. It's defined. It has a specific meaning under the contract. So you need not misuse the terms in the contract. I hope that is clear, engineers. Now, I've said that's an example of a defined term. So contractors, capital D documents, it means there's something under the contract which is defined as contractors' documents. So whenever you're in a meeting or you raise an issue and you say the contractor's documents are not in order, be very keen because there's a specific meaning assigned to that. I hope that is also clear. Having covered that, let's now go to the role and responsibilities. I'll try to accelerate a bit because we are really running short of time. The parties, we spoke about this last time. We have employer, contractor, and engineer. The financier is the employer. Of course, they own the project and they are ultimately responsible for its success. You have the contractor who is employed by the employer and does the entire construction and acts with delegated authority. The engineer is a construction expert. The engineer is not part of the contract. He's not a party to the contract, okay? Remember that, eh? The parties are number 1 and number 2. But the engineer is an expert, yourselves, selected for the project, and you possess the resources and skills to execute the work or to oversee the work, and you deliver the work as designed by the employer. Now, designed by the employer here means sometimes the engineer is the guy who's actually designed under the employer, right? Okay, you have all the time. That is okay with you. Thank you, Rodshab. The engineer may design the works for the employer and carry it on to the supervision, or sometimes the employers do not want the person who designed to be the one who does the supervision. That happens at times. The engineer is covered by clause number 2, and I've showed you how a clause looks like. So when you open your FIDIC contract and you look at clause number 2, it'll be governing what the employer should do, must do, and is obligated to do. Remember, last time in the first seminar, we spoke about rights, responsibilities, obligations, and risks. So for the employer, the responsibilities rather, are defined in clause number 2. Number 1, the employer must provide right of access to the site so that the contractor can start work. That is the role of the employer. You must give the contractor right of access. You own the plot or the road or the what do you call it in roads? You call it the alignment. You own the route alignment. So you must provide access to the contractor. The employer must appoint the engineer who acts on behalf of the employer, of course, and the employer is responsible for paying the contractor as per the contract. The employer is also may terminate the contractor if the contractor fails to perform under certain conditions, Mr. Kelvin. So being stubborn is not one of the conditions. If you look at clause 15 of the conditions of contract, being stubborn is not one of them. But there are specific instances where if the contractor has stubbornly failed to perform, not just being stubborn, but has stubbornly failed to perform, those instances are defined in clause 15, and the employer has that entitlement under clause number 2. Clause number 3 governs the roles of the engineer, and the engineer is defined as the employer's representative, but is expected to act fairly. So as the engineer, you're acting on behalf of the employer, but you have the obligation to act neutrally. The word is, I think, in clause 3.5 or fairly in 2017, but we're looking at 2019 today or tonight. So it says the engineer shall be expected to act fairly. What do you do as an engineer? You issue instructions. I've seen one of the comment from Mark, was it Mark, who said an instruction must come from the engineer. The engineer issues certificates, determinations under the contract. The engineer reviews the program. The engineer reviews the program and yes, the engineer reviews the program and inspects the works and assesses the claims. The engineer must consult both parties before making determinations. So if there's a dispute between the two parties, the engineer has the obligation to consult. Clause number 4 covers the contractor, where some of you may be working for, as some of you mentioned. The contractor should carry out the works, must provide necessary equipment, labor, and materials. I think that's fairly obvious. That's why you're the contractor. You're required to submit a program. We'll be looking quickly at that, and method statements to the engineer. And you must cooperate with other contractors on site, if applicable. So all these are governed in various sub-clauses in clause 4. So clause 4.1 all the way up to 4.24 are obligations of the contractor. Engineer has 3.1 to 3.5, and employer has 2.1 to 2.5. So who has more obligations under the contract? Just from what I've said. The engineer has 5 sub-clauses, about a page, if I'm looking at it correctly. The employer has 5, which is also about a page, but the contractor's obligations are covered across, if I'm not mistaken, across 8 pages. So obviously, the contractor has more obligations. Yes, Mr. Kalondu, that is correct. So as a contractor, you're more interested in reading this. Matthew said some people don't like reading. Anybody, if you're on site, whether as a junior site engineer, whether you are a timekeeper or whatever role you have on site, make sure that you read the contract. Everything that you do on site is governed in between the pages of this book. Read it from cover to cover and do not make any assumptions. What I've spoken about was for the red book. For the yellow book, it's slightly different, and you can immediately guess why it's slightly different, because the contractor in the yellow book does the design. Here in the red book, we say carry out the works, but when moved to the yellow book, the contractor is responsible for designing the works, submitting design documents, and the rest remain as per before, but the contractor must also carry out tests on completion and ensure the works meet the required performance. So for a design and build contract, what the employer will do, they'll issue what is called employer requirements. For the red book, you issue specifications at tender. For the yellow book, you issue requirements. What do I require for this road? I need a road with a width of, with 2 carriages, each with a width of 3.5 meters, and a traffic island in between, and traffic lights which can function for 24 hours without electricity disruption, and so on and so forth. Those are your requirements. For specifications, you actually specify the material, the equipment, everything that you require for your road. So there's a slight distinction between employer's requirements and employer's specification, okay? Be keen on that whenever you're handling the red and yellow, because that's something we also note tends to happen. Okay, so as I've said, we don't have time to cover everything. We'll just cover clause 8.1. And 8.1 issues, the engineer issues notice to comment within 42 days of contract signing. I believe that answers the question that was raised by, this question was raised by who? Titus Toom. Titus Toom said, what is the time difference between letter of acceptance and the commencement date? So within 42 days of letter of acceptance, which is usually issued upon signing of the contract, the engineer must issue the notice to commence. However, there's a caveat to that statement. If you read your contract, it's not a must that it's issued within the 42 days. It's provided the contractor has given the performance security, okay, within 42 days, provided the contractor has issued the performance security. And once the contractor has received this commencement, notice to commence, they have, I believe it's 28 days. Yes, they have 28 days to to start the works and proceed with due without actually, FIDIC says, well, I've said 28 days here. FIDIC says reasonably practicable. So I believe I should change that. It's the contractor must start within a reasonable practical period after receiving the notice to commence, okay? Not 28 days. That's quite misleading. I don't know where I got that from. FIDIC says reasonably, it uses the word, the contractor shall commence within a reasonably practical period after the commencement date, okay? Now, if the notice delays for one reason or another, the contractor may be entitled to extension of time or additional cost. We go to clause 8.2. Clause 8.2 gives you the time for completion. What's the time for completion? It's the period during which you should complete your project. We saw it in the graphic that I demonstrated a few minutes ago. And it's usually stated in what's called the contract data or the appendix to tender. So appendix to tender, we spoke about this last time. The contract is not only general conditions or particular conditions. We also have what is called the contract data or appendix to contract, the drawings and the specifications and all these other documents. So the time for completion is not stated in the general conditions, but in the contract data. And completion, what do we mean by completion? Completion means the works are ready for taking over. Now, in the course of your careers, you will hear words like substantial complete or substantially complete, and so on and so forth. FIDIC does not define such terms, but we use them in industry a lot. Works are ready for taking over when all the tests on completion have passed. So as engineers, you're charged with the duty of making sure that all tests on completion are prescribed within the contract. When you're preparing your specification or your employer's requirements, you state the tests which must be done for works to be considered ready for taking over. If these tests pass, then the contractor has completed the project. For example, if it's a road project and you say that the test is a deflection test, perhaps on the surface of the road, using the Benkel beam or whatever it is you guys use in your road projects, if you use the Benkel beam and the test passes that there's no deflection on the road, the works is ready for taking over. That's just an example. Now, time for completion is subject to extensions under subclause 8.4. We'll be looking at that shortly. 8.3 says the contractor must submit a detailed program within 28 days of commencement. Should include sequence, timing, methods, and resource allocation. So if you read clause 8.3, it gives you these three things: 4, sequence, timing, methods, and resource allocation. So that means your program should have those things. If you've ever prepared a program here, or if you've ever received a program from a contractor, those are the things that you need to look out for. Does it have a sequence? What comes after the other? Does it have a timing? When is the start? When is the finish? Does it have the methods? And finally, does it have resource allocation? So when you are having a dispute and you want to say as a contractor, my resources are idle, what are you basing your idle resources on? If you had a program, you must have indicated that for the execution of the road base, I need to have a ship's foot roller, I need to have an excavator, and I need to have 10 site engineers on site and 100 laborers. Those are my resources. And I've allocated them to that item of, that work breakdown item called sub-base, okay? You may update it as and required or when instructed by the engineer. That's also defined in 8.3. So here with me, I have, this is from Natural Projects, a program of works. Maybe some of you may be familiar with how you construct this, either using Primavera or using Microsoft Project. On the very left, you have what is called a task name. Those are the activities, right? So it starts with notice to commence, and then the commencement date, then you're given the site, then you mobilize and all those. Then you have the duration, then you have a baseline start and finish, then you have the Gantt chart, which gives you graders, rollers, water bowsers, wheel loaders, and so on and so forth. So this is typical. You'd have this in an actual project, and some of you may have seen it. Remember, we said, what do we have? Sequence, timing, methods, okay? So let's see if we have them here. We have a task name. It gives you the sequence or the order. So I, as a contractor, first need to have the notice to commence. It should have been given to me on 11th of April, 2017. And then I commence on that date, a day after, or is it, I don't know how long after, 28 days, I believe. Yes, this one is 28 days from notice to commence, thereabout. I must have the site before I commence. Then I'll mobilize, do a survey and some design, then construct my site camp. So all this, that is a sequence, right? Then you have a timing point and duration. Remember, we said timing, okay? So you have your timing point and duration. So timing, notice to commence is on 11th of April. The duration is 0 days. Construction of site camp, I've planned to do it within 84 days. For my site camp, what do I need? Those are my resources. I'll need my motor graders, my rollers, my water bowsers, and so on and so forth. So that is how a program ordinarily looks like. In less complex projects, of course, you have 10, 20 line items or tasks or activities. But of course, in more complex projects, you have millions, or not millions, but thousands of activities, and so on and so forth. Now, I said here, let me take you back, that a delayed notice may entitle the contractor to EOT or cost. Now, this one here, there was a delay of release of advance payment for 314 days, would you believe? Almost a year. So perhaps the contractor was trying to make a claim here that had this delay not occurred, then I would not have made the claim. Yes, I don't know if that's a valid claim. Maybe we'll discuss it in the next session for claims and disputes. But basically, that is what the program must have. Your program must have all those things for it to be valid under the contract. Now, which software do you use ordinarily? I've seen programs in MS Excel. MS Excel is a good way of showing events chronologically, okay? It's also a good way of annotating them with a short comment. You can generate an S-curve. You can manipulate it depending on how good you are with Excel. I've seen some people work magic with the normal Excel that I use to do 1 + 1. Other people work magic with it. And yes, it's good for presentation and color charts and so on and so forth. And it's easy to use. Primavera is another one. Some of you may be skilled using Primavera. And you can you have knowledge of schedule costs, and it has a good graphic, and you can use multiple users since it's online. So you can collaborate across borders and across offices and so on and so forth. And then, of course, MS Project, this one is most popular. It's good because people can compare as built against baseline. You can identify the critical path, float, logical links, and so on. I mean, the critical path is the PM, the project managers here can tell us, but I understand it's the longest path to completion, right? That's how it's defined. So the tasks which lead you the longest to completion, those are called the critical tasks, and they fall on the critical path, ordinarily highlighted in red in the project. Yes, so those are the 3 softwares. There may be others. I know there's Aconex and all those others, but ordinarily in a normal project, especially in Africa, because of cost, you'd encounter these 3. So which one do you want to use? Probably preference. If you're using FIDIC 2017, FIDIC 2017 actually specifies that the software must be defined in the contract data or the appendix to tender. So you as an employer, when drafting a contract, you must say the contractor must use Primavera. I think in 2017, they say this because they realized between 1999 and 2017, there are a lot of disputes about the result. Would you believe if you construct a program with MS Excel, you'll not have the same outcome if you do it with Primavera when analyzing delays? But that's a matter for a different seminar. I trust that is sufficiently covered, and if you have any questions, just drop it in the chat. I'll look at it. Yes, I'm seeing MS Project. Primavera is the current software we use. MS Project. Yes, okay. I've seen people use MS Project quite a lot. So 8.4 speaks about extension of time. The contractor is ordinarily entitled to an extension of time. So you have the time defined in the contract for extension. Sorry, for completion, time for completion. So you say this road project shall take 2 years or 730 days, but you may extend under certain circumstances. What are these certain circumstances? If a delay occurs because, number 1, of variations, number 2, are caused by the delay, employer's delay, the employer is meant perhaps to relocate squatters who are by the side of the road, or vendors, roadside vendors perhaps, or do some land acquisition, which happens a lot, and the employer has not secured the funds to do this, the contractor is entitled to an extension of time. You may have adverse weather, you may have unforeseeable conditions. They're all defined in the contract. And you may have what contractors love using, but they're always wrong when using this, force majeure. Many a contractor likes to jump on the force majeure clause. If you look at the force majeure clause, it's very stringent. It's very difficult to satisfy for an event to satisfy force majeure. Would you believe during the 2020 FIDIC, the 2020 COVID era, very few claims by the contractor passed the test for force majeure during COVID, mark you. Very few globally. I think it's on some global reports. You may be able to look at them. The dispute resolution reports for 2020. Very few contracts accepted COVID as a force majeure event. And you can imagine the scale of COVID. So whenever you're a contractor and you're looking for easy money, perhaps that is not the clause to rely on to build your claim. You may look for others, and there are many others, but force majeure, ordinarily, it's very difficult to demonstrate and prove that you're warranted an extension of time as a result of a force majeure event. What are the clauses which, so here, now if this is not the wording of clause 8, I've summarized it. All this is not the wording of the contract, by the way. I've been summarizing, or how do you call it? Paraphrasing. I've been paraphrasing. So this is not the wording of the contract. But if you look at the wording of subclause 8.4, it says the contractor shall be entitled to an extension of time under any clause in these conditions. So what are the clauses in these conditions that entitle the contractor to an extension of time? Okay. Any delay or impediment caused or attributable to the employer under a clause of this contract. What are these clauses? They're all listed here. 1.9, delayed instructions and drawings. This happens a lot. There's a reason for a delay from the engineer to the contractor. The contractor is entitled to an extension of time. If there's a delay in the right of access to site, I've just mentioned that. Ordinarily, this happens with compensation issues. The contractor is entitled to an extension of time. If there's another contractor on site and the contractor is required to cooperate with this contractor, and sometimes, let me see, for the case of a road project, so you have a road project, the contractor doing the road project, and perhaps you have another contractor doing relocation of facilities which were in the route, in the alignment. Do you call it alignment? Mr. Rhodes, do you call it alignment? The route where the road is intended to pass. So if there's another contractor working within the alignment for whatever reason, and this contractor is expected to cooperate, and the cooperation causes a delay. So you're expected to cooperate with a contractor carrying out fiber works, fiber internet. And so you're told pause between kilometer 1.1 and kilometer 1.6. Pause your construction because we have another contractor doing fiber works in that section. You'll stop for a couple of days and it will impact your program and you'll be entitled to an extension of time. Remember, I'm using the word entitled. I'll get to it in a short while. Then you have all the other conditions. I'll not go through all of them. You have unforeseeable physical conditions, fossils, testing, clause 8.4 itself, extension of time, delays caused by authorities, consequences of suspension, delayed test, interference, etc., 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 up to the most famous one, force majeure. And each of these entitle you to some cost considerations, but here we're only talking of extension of time, so I'll not cover that as well. And so what is the extension of time procedure ordinarily? You have a circumstance or an event which has occurred. What is a circumstance or an event? The employer has told you, please pause between kilometer 1 and kilometer 1.6. That's a circumstance. What are you going to do? Cross your arms and wait for the instruction to proceed. So within 28 days of that circumstance or an event, you must give what is called a notice, capital N. When you give a notice, you inform the employer that I have been instructed by your engineer to pause construction between chain edge 1.1 to chain edge 1.6, and this shall invariably delay my time for completion. Within 42 days of that, you should give detailed particulars. How did this stoppage for 2 weeks between kilometer 1.1 and kilometer 1.6 affect you? You must give detailed particulars. So entitlement is one thing. Yes, you're entitled, but justifying the entitlement is the second thing. And you justify it in what is called detailed particulars. We shall be looking at that in the next seminar, so stay tuned for detailed particulars of claim. And finally, within those 42 days or earlier or later, we hope that there'll be an end of the event. Once there's an end to the event, you have 28 days to give a final detailed claim. So this one here is what is called an interim claim. This one is called an interim claim, and this one is called a final detailed claim. So you can see that FIDIC is very procedural. It's 28 days, timelines this, timelines that. And Kataboy asked about timelines. And if you sign a contract, you agree to the terms of that contract, subject to applicable law. So if there's any conflict, it is upon you as the engineer to clarify which one prevails. Is it the timeline in the contract, or is it the timeline in the governing law or the applicable law? Ordinarily, the law takes superiority, but I've successfully argued a case where the contract took superiority because we signed the contract. So we didn't sign the law. The law is for somebody else. We signed this contract and we won. But ordinarily, the law takes superiority. Within a given period, it's not stated. I've put question mark there, but FIDIC uses the word reasonable. Again, the engineer must determine or agree to the extension of time. Okay. So very quickly, we move on to this one. This is just a demonstration of what you have. Ordinarily, you have what you call a baseline program. Simple: clear the site, excavate, lay the pipe, backfill, testing and commissioning. You had planned it in 10 months and you have your original completion, but a delay event occurs. So this is the event or circumstance, late possession, and it impacts your commencement. You cannot start clearing the site because you do not get possession. So of course, you must justify that there has to be an extension of time. You must prove this as a contractor for you to be awarded. Late possession is a circumstance. Yes, it gives you entitlement, but it does not guarantee an extension. You must demonstrate that this late possession caused an impact to your program that resulted in an extension time. Okay, so that brings us to the end of that section. I want to cover all the material so that I can answer your questions. We have a small case study at the end, so I'll just keep dropping your questions. We'll cover all of them towards the end. How reasonable is reasonable? What's the test and limits of reasonability? That must be a lawyer speaking. I think Mark is not an engineer. This guy must be a lawyer. He must be a lawyer. Anyway, valuation is covered in clause 12, 13, and 14. We're going to cover that quickly. The red book or the construction contract is for measured contracts. The yellow book we've mentioned is for lump sum. The silver book is for lump sum contracts as well. So somebody in the beginning said red and yellow book. I've seen people try to mix the two books. You can't mix, choose one, okay? Because the valuation in this one is different from the valuation in this one. Now, three main clauses apply. That's clause 12, 13, and 14. There's some differences between the forms of contract, 2017 and 1999. It's important to have a guy like myself, a contract manager, to look at the differences because, yes, you know the principles, but there are very slight differences which impact how the valuation is done. Now, measurement and valuation only applies to the red book, again, because we've said it's a measured contract, so not in yellow book. This clause 12, okay? Clause 12 applies to the red book, and the engineer shall give reasonable notice of when, oops. Sorry about that. The engineer shall give reasonable notice of when there's a streak which keeps appearing on my screen. I don't know why. The engineer shall give reasonable notice when he requires the works to be measured. Now, ordinarily on site, it's the contractor who calls the resident engineer, hey, Mr. Engineer, let's go measure the works. But the wording of the contract is that the engineer should give notice. Reasonable notice. Again, the word reasonable appears here, Mr. Mark Oroko. When you want the work to be measured, and the contractor should attend or send a representative. If you're on site, like Fumbani said, he's on site as a contractor. you go measure. If you do not attend, then the engineer will take the measurement and deem it as accurate. If it's measured from records, some contracts specify that the work is measured on records, right? Not on the road. So you just measure the drawings. Records simply means drawings, right? The engineer shall prepare these records. But do you see this in practice? Usually, even if it's measured from records, it's still the contractor who does the preparation of records. And, the contract just says the contractor should examine the records and give notice if they don't agree. But usually in practice, still the contractor prepares the records and presents them to the engineer. That's what I've seen, at least in the span of my career. The engineer then confirms or varies the record, and if the contractor does not notify that they disagree with the records are deemed accurate. So that's the wording of the contract, and that's how measurements and valuation should be done. But in practice, we've seen all kinds of things happen, but that's how it's stated it should be done. Now, the engineer agrees or determines by evaluation of each item of work by the appropriate rate of price, which is indicated in the bill of quantities, okay? Now, contract rates and prices apply, and new rates may be applied under certain cases. Work does not stop because you've disagreed on the rates and prices. It's clearly stated. So the contractor cannot say, hey, I'll not work until you agree on this rate. No, the work does not stop. You must proceed. It's clearly written in the contract. Sometimes there's an omission. So the employer may decide, hey, I no longer want traffic lights or traffic signage. Let me omit that. Then the contractor shall give notice to the engineer. If we have time, we'll look at a case study of omissions. Now, you cannot omit works to give it to another contractor. That's forbidden in the contract, but we see that again happening a lot. So if you're working for a contractor and anytime the employer omits some work and you understand it was given to somebody else, there's some money you can make. Who does the measurements? Is it the engineer or the QS? Hey, guys. Who are the parties to the contract? Whoa. I've gone so far back. I need to address that.
The engineer, the contractor.
Yes. The engineer, the contractor, and the employer.
And the employer.
Yes, so I don't know why this guy is asking about the QS. Those guys. Now, the engineer may delegate authority to somebody called the quantity surveyor or the measurement engineer and so on and so forth. The authority may be delegated. If you look at clause 3.2, it speaks of delegation of authority. But whoever that person is called the engineer. If you, as Mr. Sebastian, are sent by your resident engineer to site to do a measurement, you are the engineer under the contract. Okay? So there's no provision for quantity surveyor or measurement engineer under the FIDIC contract. If you're using another contract, perhaps, but if you're using FIDIC contracts, you are the engineer. The quantity surveyor, the measurement engineer, the site inspector, the clerk of works, whatever name or title is given, you are the engineer staff, and authority has been delegated under subclause 3.2. Okay, so authority must be delegated. I hope that's cool. There was a question here which I found interesting. I need to pause and ask it. Then I request, okay, in case the contractor measures alone, then I request for verification of quantities. Well, this is Matthew just stating how he does it on site. He says he prefers joint measurement, which is a good idea. Esau, okay, we'll go back to that. Okay, so I needed to clarify that for you, Mr. Sebastian. The QS acts as a delegated authority. So that is the engineer. The name of that person, unless you've meddled with your contract and you've introduced a fourth party called the engineer, the QS, which is not correct. Okay, so let's look at variations, which should be the last thing we look at. Variations are under clause 13. A variation is an instructed change to the baseline and agreed scope of work. Subject to contract wording, should include time and impact as well as cost impact. Now in FIDIC 1999, variations are covered under clause 13. You have the right to vary. The engineer has the right to vary the works at any time. Again, Matthew Ochoria. So the engineer has the right to vary, regardless of what the Solicitor General said. The engineer has a right under this contract. You can argue it later, but the engineer has the right. The contractor can propose value engineering if it will benefit the employer in terms of cost or speed of execution. There's a variation procedure given in clause 13.3. 13.4 speaks about 13.4 speaks about payment in applicable currencies. I don't think so. That's not 13.4. I don't know how I put that there. Oh yes, it's 13.4, payment in applicable currencies. 13.5 speaks about provisional sums, then day works, then changes in legislation, and changes in cost, okay? So a variation is defined. It's a defined term. Remember, capital V. A variation is defined in subclause 1.1.6.9, and it means any change of the work which is instructed or approved. So variations can come under two ways, instructed or approved. If it's instructed, that means the originating party is the engineer. If it's approved, that means the originating party is the contractor who has requested for approval of a variation as perhaps a cost-saving measure or time-saving measure. So whenever you receive an instruction as a contractor, you must confirm that it's given under clause 13, okay? Not all instructions are variations, and ordinarily not engineers don't always instruct variations. So as a contractor, be careful to confirm that. What are the criteria which give rise to a variation? Changes in quantity, changes in quality, changes to the levels, omission, any additional work, sequence, and timing. So if any of these things happen in your project, then that constitutes a variation. Not always, but mostly. Somebody says client's representative on site. Who is the engineer? The inspector, full-time supervisor? Guys, Matthew. The engineer is defined in clause 3.1. The engineer is appointed, okay? The engineer is appointed by the employer. The engineer is defined as a legal entity or person, okay? Let me read out the wording. I have the contract here. Let me read out the wording for your benefit. The employer shall employ the engineer who shall carry out the duties assigned to him in the contract. The engineer's staff shall include suitably qualified engineers and other professionals, okay? Suitably qualified engineers, yourself, and other professionals, your surveyor, your supervisor, your quantity surveyor, as you mentioned, health and safety personnel, etc., etc., who are competent to carry out these duties. So for measurement, the engineer shall appoint or shall delegate that role, which is the role of the engineer, the firm or the individual or the legal entity called the engineer. This role is then delegated to a measurement engineer. What is this role? Measurement. You have health and safety. This role is delegated to the health and safety officer, and so on and so forth. Okay? You have it's a survey. You have tests and commissioning. You have a materials engineer. So the role of the engineer is delegated, but the engineer under the contract, capital E, capital E, the engineer under the contract is the legal person or entity to whom the employer has appointed. So the employer will not come to me, Barasa, and employ me. The employer will come to Rodsab and Company or Matthew Ochoria and Company and employ you as an engineer. Then Matthew Ochoria and Company shall delegate based on his employees, an inspector, a site surveyor, etc., etc., shall delegate all this authority for approvals, checks, consents, measurements, and all these things. Okay, so the engineer is a defined term under the contract, guys. So and you can see I'm using it in capital everywhere, right? Wherever I'm putting it in capital because it's a defined term. It's not the profession of engineering. Perhaps that's where the confusion is arising. The engineer does not mean a person who's practicing that profession. Myself, for example. In the project I'm not the engineer. No, the engineer is a defined person, a firm ordinarily or a company. And that firm will then have the personnel or the qualified staff, which FIDIC says, suitably qualified engineers and other professionals to carry out the duty. So subclause 13.1, we've mentioned, right to vary. Subclause 13.2, value engineering. 13.3, procedure for instructing a variation. 13.4, payment in applicable currencies. 13.5, provisional sums. 13.6 deals with day work, which is where work of minor or incidental nature is to be carried out. 13.7 deals with cost arising from changes in laws. 13.6.8, adjustments to changes in cost. We may have time, if you allow me, to do a small exercise on this so that we close. And then, yes, so it's important to recognize changes and know subsequent actions to take. How do you recognize changes? You inspect if they meet this criteria defined in subclause 13.1. Is it a change in the quantity of any item? Were you meant to supply 50 traffic lights and suddenly you're instructed to supply a traffic light every 10 meters, which increases the quantity? Is it a change to the quality? Were you told to do a road base with a certain gravel size and now you're told to do a different gravel size, levels perhaps? Omission, remember it's not to be carried out by others. Any additional work, including tests, if you're told to do additional boreholes, for example. Changes in sequence and timing. This happens a lot in our regions, right? A minister comes and says, I need this road opened by December. So forget about this lower end. I need kilometer 1 to 1.6 opened. That's a change in sequence. That's a variation. You can claim for that and so on and so forth. Some proactive steps is to read the contract. I told you, all of you must read the contract. So I hope from this meeting, the first thing you'll do tomorrow, you'll open your contract and read it from cover to cover if you've never done so. Monitor your obligations, document the change and give required notice, and maintain records. Records. You need to identify and quantify the time and cost effects. I won't get into omissions. It's a whole day's topic, but in short, sometimes the employers decide to descope or to carry out omissions. This is a full day topic, guys, but basically maybe funding problems, so you remove a certain scope. Maybe the employer finds a cheaper contractor, removes the scope. Maybe they realize this contractor is not capable, remove the scope. Or there's poor performance, like the stubborn contractor of Mr. Kelvin Macharia. So you remove the scope and give it to somebody else. But we won't get into that. There's a lot to unpack in omissions. I wish we had time. There's a lot to unpack there. Lastly, payment. Now there's something called contract price. Remember, you have the accepted contract amount. And then at the end of the project, you'll have the contract price, what you ultimately paid. So this is determined as per subclause 12.3. Don't mistake contract price with accepted contract amount. Those are two different things. It's adjusted as per the contract for any additions, e.g. cost or plus profit or deductions. Then you have advance payment, which is an interest-free mobilization loan, which the contractor is given to kick off the works. Then you have your interim payment applications. This is what many engineers call claim. Please do not call this a claim. It's an interim payment application. It's defined and is under subclause 4.2.1. A claim, capital C, is something else. So the contractor never submits a claim for payment. No, they submit an interim payment application. And as the engineer, capital E, you review it and approve it. Okay, I'm seeing guys are dropping out of the meeting. I'm conscious of time. We are almost about to finish, so please bear with me. There's an interesting exercise at the end. Don't drop out until the very end. I understand it's quite late. So what happens during payment? What is the process for payment? The contractor submits what is called a statement. The engineer has 28 days to certify this statement, and 56 days from the date of submission of the statement. I know a question will arise from here. I know this question, it's been asked millions of times. You have, as the employer, the obligation to make payment upon the certification. If this payment is not done, the contractor shall give a notice of not less than 21 days to suspend the works. And if the payment is not remedied under subclause 16.1, within a reasonable time, Mr. Mark, the contractor has the entitlement to terminate within a reasonable time after the notice is given. So that's the linear progression of payment. Okay, I know the question which will be asked on that. So that's the certification and payment. Now, after the contract, you have another, this is just a graphic to define what I was saying. Okay, that's just the same thing. Then you have retention money. So ordinarily under the contract, you keep aside some money as an employer, which will be returned upon taking over, 1/2 of it, and the remainder upon defects notification period. So as engineers in your career, you may be charged with reviewing of contractors' applications and prepare the certificates. You put aside a certain percentage of the contractor's application, and you will pay it first half upon taking over, and second after the defects notification. Remember the graph I showed at the beginning? All this is related, okay? Delayed payment. If you delay to pay as an employer, the contractor is often entitled to financing charges, or as some call it, interest on delay payment. And this is under subclause 14.7. Once the work is done, there is what is called a statement on completion, which is submitted within 84 days of the taking over certificate, detailing all works done, etc., etc. But that's not the final payment certificate. Remember, we have taking over, and we said we have the defects period right after that. Which clause talks about payment? I'm failing to see it here. My friend. Okay, clause 14.7, clause 14 talks about payment. So from 14 point, well, I mentioned it though. Maybe I went too fast. I mentioned it here, measurements and evaluation. I mentioned it here, Mr. Kalendu. 3 main instruments govern finance in FIDIC. Payment is clause 14, okay? But it's tied to these others. So you pay what has been measured, you pay any variation, and you pay any adjustment. So all these are related, okay? I hope that sufficiently answers your question. Yes, I think we have covered all the material. So once you've completed the work and the defects notification, you give the final payment, you give the performance certificate, remember the graph, and you issue the final payment certificate, okay? And that is the procedure for the final payment certificate. You may take a screenshot. I don't have time to cover it, but basically taking over, first half of retention is given, then statement at completion, second half. If there's a dispute, the engineer, you issue a payment certificate of the agreed parts, and the others are adjudicated later, because ordinarily a dispute is only for some disagreed parts. Other parts are agreed, okay? And then you give what is called a discharge. Mr. Contractor, thank you very much. We are done. And the engineer issues a final payment certificate. This is FIDIC MBD 2010, not 1999. So some minor differences in there, but never bother about that. Okay, I've spoken quite a lot today. I know I've rushed through the slides. I'll take the next 5 minutes to answer your questions. And then the 5 minutes after that, so we'll finish at exactly 10:15. The 5 minutes after that, we'll spend them to do a case study. I want to post the case study in the comments while I address some of the questions that were in the, in the chats. Then you look at the case study, answer it in 5 minutes, quickly, and then we close. So I go to the questions in the chat. Let me start with this one. So we have substantial completion, and final completion. Please enlighten. Mr. Matthew Ochoria. Substantial completion is an industry term. It's not defined in FIDIC. FIDIC does not have any term called substantial completion. People use it though, because if you look at clause 10.1, it says, if the contractor considers the works have been substantially completed. So people say substantial completion, and it's become a defined term, but it's not defined in the contract. But basically, it just means the contractor considers that these works can be used, okay? I can hand over this work. If you're doing a power plant, for example, what would be substantial completion? If you're doing a power plant, substantial completion obviously would be the power plant can generate power. If you're doing a road, substantial means traffic can pass on the road. So you can argue that I don't need to put traffic signs because they're not substantial in the grand scheme of things, but that is not a defined term. You have completion. I said at the beginning, when I drew that graph, that completion means I said at the beginning when I drew the graph, that completion is when the tests on completion have passed. And that is defined in the contract. So you need to define within your contract what tests on completion are, so that nobody argues that these works are not complete. Okay, tests on completion, 9.1. Once these tests have passed, then the work is complete and is ready for issuing of taking over. I trust that clarifies your question, Mr. Matthew. Final completion is, yes, final completion is also a term. I think that comes from West Africa a lot. They use it a lot. Final completion. There's no final completion. Hey, you complete the works, do the tests, I give you a taking over certificate. And upon the conclusion, I'll return the performance security once the defects have been rectified. Okay, so you must make sure that that part is clear. Where does JBC lie? I don't understand that, Mr. Sebastian. So we have, how best can you apply the change in rate as per clause if quantity is more than double? You do as it says, Mr. Ayub. It states there very clearly, 12.3. It states there it states there very clearly what happens if the rates are more than double, unless you guys modified your contract. But it states there clearly what happens. It gives the percentages if I think you meant 13 point, did you mean 12.3A? I wonder why you say 12.3. I think you meant, oh yes, this for FIDIC Red Book. Okay, yes, you meant 12.3A in FIDIC Red Book. It states there what happens if the quantity is more than double. So it states in the paragraph right after A, B, and C, it says there. So if you read the contract, you'll see clearly what happens. Okay. Please, can I get these notes? You'll speak to Roads Hub. At what point do termination apply if there's also interest on delay payment? Interest on delay payment has nothing to do with termination. The clause for termination gives certain conditions for termination, and interest on delay payment is not one of them. Conditions for termination is who's terminating here. So there's two terminations, the termination by the contractor or termination by the employer. Both of you have equal rights. If the contractor abandons the work, employer can terminate. If the contractor excessively delays, employer can terminate. If the contractor fails to comply with any condition, 4.2 performance security, employer can terminate. All of them are listed. Interest on delay payment is not a cause of termination, Mr. Junior. Which clause talks about payment? I've answered that. After signing the letter of acceptance as a contractor or subcontractor, is there a period for the contract to remain valid? That's a legal question, but the contract remains valid for as long as the contractor's obligations exist. Okay, so your obligations are to complete the work. The time for completion defines the contractor's obligation, and after that, the defects notification period. So to answer that question, perhaps I can say the contract is valid until the works are complete and the defects are rectified. Any comments on FIDIC? I'll answer that in the next seminar, Mr. Mark. Reason as to why most of the projects are failing. Okay, that was a general comment. Why is FIDIC silent on contract agreement signing timeline? It's not silent on that, Mr. Titus Toom. I've clearly demonstrated on the screen. There's timelines for that. It's not silent. It gives everything about it. Well, you call it contract signing. FIDIC calls it issue of letter of acceptance. Remember in the first seminar, we talk, what is a contract? Offer, acceptance. Okay, you must give me an offer and I must accept. That is how a contract is formulated. So the offer is what you're calling here tender. Is my screen sharing still on? We're calling it tender here. That's the offer, and then acceptance. Once it's accepted, obviously you've signed the contract. So maybe that's the confusion. Contract agreement signing. Well, I'd refer you, Titus Toom, to your FIDIC conditions of contract, and perhaps you can look at clause 1. If you're looking at the red or yellow book 1999, look at 1.1.3, is it? Sorry, let me just confirm. Look at 1.1.1.3. 1.1.1.3, it covers your question adequately, okay? I'll write it there for you so that you don't forget. It covers your question. FIDIC covers everything, eh? FIDIC covers everything. I think I've addressed those questions. Those other questions before we go to the case study and before more of you drop out, those other questions relating to the first part, let me rush up. Yes, we had these questions. Gidaka, you're sharing the screen? There was these questions. If a contract is lump sum, is it possible to claim for variation? Yes, there's a variation even in lump sum contracts. If cost of execution is skyrocketing in this item. Yes, there's ways you can claim for it. There's a clause for variation in contract. So look at that clause in even the lump sum contracts. Look at it and see what it says. The engineer can be firm and can be a firm and under which a natural person, which yes, that is correct, Marolin. That's exactly what we were talking about. I'm looking at the comment by who else? Kelvin Macharia, QS is part of the engineer staff. That's correct. We discussed that. Ayub, do all EOT come with costs to be paid to the contractor, or no, not all extensions of time come with costs. Some come with costs, others with cost and time, others come with cost, time, and only cost and only time, and so on and so forth. So it's important and up to you to look at which one of those you are, your claim falls under, okay? I think I shared that on that screen, which spoke of cost and time and so on and so forth. Yes, I think I've covered all those questions. If there's any that I've not covered from before, maybe I'll address it in the future seminar. The change in rate in clause 12.3a, is that it's directly proportional to? I don't understand your question, Ayub. 12.3a, does 12.3a talk of change in rate? Ah, okay, yes. Yes, 12.3a. Well, if there's a change in rate that is directly proportional to the quantity increase, then you are entitled to the caveat which is given right under paragraph B. But remember, there's the word and or right after that contract, right after that clause. So it says and. So all those conditions have to be fulfilled. It uses the word and. So it's not only one. So it's not only the change in rate. Now I understand your question. So if you look at subparagraph 12.3a, it says a new rate of price shall be appropriate if an item of work, then it goes on to list that shopping list. It says A, B, and. Okay, so it says and. So all those must be fulfilled, not just one. And that's a catch that many contractors fail to get. But if you fulfill any of them, you can argue your case, but usually it must be and. Can you mention something about expiry of performance security during contract tenure? Yes. Subclause 4.2 states that the contractor must maintain the performance security throughout the contract duration and until the performance certificate is issued. So it's upon you as the employer to ensure the validity. And you can look at subclause 4.2 where it specifies when. I think it's 28 days before the expiry, you must notify the contractor to extend it. If it's not valid, under clause 15.1, you can terminate the contract. Easy, that's easy. Can the firm which did the design on behalf of the employer also be appointed as the engineer? Yes, that is the best. You must appoint the guy who did the design. I'm seeing more guys are dropping out, so I'll have to pause there, guys. Unfortunately, have taken so much of your time. If you've done the question, or let's do it within 2 minutes and just share the responses, then we'll discuss it. Lots of guys have dropped out and I don't want to keep you here longer. I'm sorry, I'd love to go through each of your questions in detail, but it's just that we are constricted for time. So the question is in the chat. We can go through it together due to time. Or what do you suggest, James? Because I'm also tired, just as the participants are tired. I too am tired.
I know. Yeah, sorry. We can just quickly go through it without necessarily doing the calculation, just to give an idea of how to approach it. Engineer, you are muted, please.
Okay, so we have the price adjustment under FIDIC 1999. This is for your seminar. The aim is just to make sure that you know how to apply this formula in clause 13.8, and you can apply real cost indices and interpret whether the change in cost is beneficial or not. So you have this, if you have an Excel sheet open, you can quickly open it and just copy paste this stuff into your Excel and see how to work it out. So you have the initial coefficients. Now, what are these coefficients? These ones are filled at tender by the contractor, and you give it a percentage. All this should add to 1. A coefficient is a weight. So you're saying that for labor, you've allocated 10% of the project cost to labor, and 25 to equipment, and 35 to roads. So you can immediately see that a contractor, for a road contractor, for example, they'd want to put more weight on equipment, I think, because roads are more equipment heavy. If it's, let's say, if it's, I don't know, a power plant, perhaps, maybe they'd want to put it on materials because you have a lot of installation in there. Maybe, I don't know. So you put these weights at tender and you give them weightage. Thereafter, there's what you call the base indices. So the question was posed in the chat by, was it Gift, who asked, where does the base date apply? This is where the base date applies, one of the places. It applies in many other places. These base indices are those valid as at the base date. So 28 days before the deadline for submission of tender, you must have certain base indices for your labor, certain base indices for your equipment and for your material. Now, where do you get these base indices from? I'll show you an example of a table of contract data. I have it here. Do I have it? I have it in my slides. There. There. So you have these indices, this from a real project, and there's source of index. So various governments publish different sources and you can get them from there. So basically that's the purpose of the exercise. Please see if you can answer it. And if you join next time, perhaps you can go through the solution for that one. My sincere apology for taking much of your time, but it's very straightforward. You can answer it and we'll see. If you have any other questions arising, perhaps in the next seminar, the roadmap will announce when it will be. We'll look at disputes. I'll keep time. And I also request you to keep your questions concise so that we cover more ground. Okay. Thanks a lot. I hope you've learned something, even though we've quite rushed, but you've learned something.
All right. Thank you very much, engineer. I am very, very honored to have you. We understand that you had a lot planned for us. And we also want to be very grateful for actually taking 2 hours of this time to speak to us, even though we know that you had a very busy day and you are tired. So please receive our gratitude. Thank you very much. I don't want to preempt what has already been covered, but I just want you to know that we are very grateful, and we look forward to, I don't know, just take a rest, engineer. Thank you very much. I don't know what else to say today. Matthew Oshori has been one of the person who has gotten the highest number of responses to their question. I would like, therefore, to ask him to send a vote of thanks and close the program, or rather close the day for us. Please, if you get some time, if you have any contractual issues, you know the expert. It's Barasa Ongeti with an S on LinkedIn, and he will always be ready to serve you. He will be launching his FIDIC training programs, and you already know, you have already seen the tip of the iceberg. Once it's out, I'm going to be notifying you so that we all go there, get to learn, become very good. Thank you. Matthew, please. a brief vote of thanks, and then we close. Thank you.
Good evening once more.
Good evening.
Allow me hit the nail. Engineer Barasa, thank you so much for this evening. Actually, having this second session has been quite enlightening. It's giving us at least a hint as fresh engineers in the market of where we are going. So as you continue, I think the last session, we are looking forward to getting more of this baseline as we get into the market with solid mind. That is one. So I would like to appreciate for your time and not forgetting Roads Hub for bringing you in the channel and getting the young engineers aware of the projects or what happens in projects. And one of the lions, that is the FIDIC contract, FIDIC regulations. The other thing is, yes, you're giving us the look of what we should expect. And we shall be looking forward to your official sessions. And we hope when that time comes, you said something that will at least give us courage. You said something that will help us be in position to face the experts in the market. So we shall be looking forward for the sessions, especially next session and the other programs that you'll be giving to us. To other engineers, thank you for your time. Thank you for supporting Roads Hub and basically supporting yourself. So thank you so much.
Thank you, thank you, thank you, thank you, thank you. May you all have a fantastic night and see you next time. Take care of yourselves. Make sure you read the contract. Read, read, read deeply, widely, intensively. That is the most important thing. Some of the questions will be answered in reading. Thank you very much. The session is, I will end the session now. And the recording shall be shared to all of us. Asanteni sana.